The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Attorneys who are not in the first case, please turn off your cameras and mute your microphones for right now.
Okay, good morning, everybody. Welcome to the Fourth Circuit. We have three cases on the docket for hearing this morning. The first case is United States versus Perpera. And we are prepared whenever you're ready, Ms. Westover.
Thank you, Your Honor. Morning, Your Honors. May it please the court, counsel. My name is Blair Westover, and I represent defendant appellant Frank Perpera. Obviously, I'm interested in whatever questions Your Honors have, but where I was hoping to start out today was the question of whether the court's colloquy with Mr. Perpera after the motions hearing on January 29th constituted a valid waiver of the defendant's right to conflict-free counsel. And the reason I'm starting there is because I'm concerned that the implication of finding the waiver on this case valid is how heavily dependent it was on the advice of counsel who were themselves conflicted without any independent admonishments from the district court.
Counsel, hi, sorry, this is Judge Harris. Can I just ask you a question about the waiver point? Is it I'm trying to figure out how this fits with the rest of your argument. Is it your understanding that this per se rule you're arguing for, does it mean only that you don't have to show an adverse effect on performance where there's a conflict? Or are you also arguing that if there is this thing called a per se actual conflict, it's not waivable at all? I'm just does the waiver, yeah.
I see our brief argued that if there was a per se conflict, then we don't have to show the adverse effect. I don't know if we directly said so in our brief. I think if you look at the court cases, if there is a per se conflict, it's also not waivable. If that makes sense, the two tend to go together. But I think in this case,
although the cases treat them differently.
The cases do treat them differently, I agree. I think there's sort of logical correlation there, if you will. If it's automatically a conflict, it seems like it's something you can't waive. And if you can't waive it, it seems like it's automatically a conflict, if that makes sense. But I agree, the case law treats those differently.
Well, then why are you, okay. But nevertheless, you want to start with waiver. So you're assuming there's maybe something here that can be waived.
I think that the government agrees at this point that there was an actual conflict. And as a secondary argument, we argue that it's per se. The reason I'm starting with waiver is because if it isn't a per se conflict, we're going to have to get to it. And my concern again here is I think it's risky to rely so heavily upon the advice of counsel to establish a waiver. So for example, in Brown, this court said that a defendant must be advised not only of the crux of the conflict, like the source of it, but the possible implications. And the only people who could plausibly have discussed those implications with the defendant were counsel who were conflicted. And I do, yes, Sharon.
But even in the Second Circuit case law that has found a per se conflict, don't the two alleged crimes have to be similar? That is, the conflict for the attorney, which is, I guess, alleged witness tampering. Doesn't that have to be substantially similar to obtaining controlled substances fraudulently?
If you're talking
and how are they similar?
Sure. If you're talking about a per se conflict, I agree that it's not just any investigation out there in the world that a defense attorney might be under that can give rise to a per se conflict. The distinction the government wants to make is that, well, this might have had to do with witness preparation.
But wait, I thought you were arguing for a per se conflict.
We're arguing both. I'm arguing if it's per se, then we win. If it's not per se, we think we can
Okay,
establish
so-
adverse effect.
So that gets back to my question. How can it be per se if those two things aren't substantially similar?
I think that if the defense attorney's conduct is related to the investigation of his participation or investigation of the defendant's case, then even though it's not related to the underlying crime that the defendant is charged with, I think that that's an extremely problematic situation, and I'm not sure that the distinction matters, because in both situations, you're going to be dealing with the defense attorney asking questions about or being put in the position of cross-examining someone with whom, in this case, Clara Kraft, with whom the government is alleging he engaged in misconduct.
Okay.
But I agree, I understand the government's argument on that point. I just think that because this is related to the investigation of the case, it's closer to related than just a completely random investigation somewhere out there in the world.
Ms. Westover, does it matter that in this case, the charging authorities, the prosecutors who were involved in investigating your client's defense counsel were the same prosecutors who were prosecuting the case against your client? And the reason I say that is it would seem to me that a lawyer who had an incentive to try to curry favor with a prosecutor obviously would be much more inclined to do that in the same case in which the prosecutors were one and the same. Does that make sense?
That does make sense, and I think that's absolutely correct. Are
there any cases that make that distinction that you're aware of?
I'm not aware of them specifically. Well, there are cases that emphasize, and I'm not going to be able to come up with those names off the top of my head. Maybe while the government's speaking, I can find them, that emphasize the language that the very prosecutors investigating the defendant are also investigating the attorney, that emphasize that language. I'm not going to sit here and claim that I recall I can find any case that hinges directly on that. But I do think that matters.
Counsel, sorry, it's Judge Harris. So I'm trying just to pick up on what Judge Diaz was talking about. If that's your theory, that if it's the same prosecutors, you're going to be, maybe you could argue the lawyer would feel sort of compelled to back off so as not to anger the same prosecutors who are investigating him for something else. Then it wouldn't really matter, right, whether or not it was related to the crimes committed by the defendant. And it might also apply even, I mean, you started by saying this isn't going to be any, and it's not enough that the lawyer is being investigated anywhere out in the world. But if it's by these same prosecutors, it might be enough, even if it has nothing to do with the case in question, right?
Right. Well, I think, okay, so the question is whether or not it's a per se conflict. So there are like three imaginable situations, right? You've got an attorney that's investigated totally unrelated. Now, I think we all agree, even then, there is an actual conflict and there does need to be a waiver, right?
But why isn't it a per se conflict if it happens to be the same prosecutor that's prosecuting the case in question?
I think there's a very strong argument that it should be a per se if it's the exact same prosecutor, especially if it's the exact same prosecutor and it's on a fact that's related to the preparation for the defendant's trial. I absolutely agree. I think in that situation it should be.
But it wouldn't have to be. I don't understand why it would have to be related to. I have a concern. My concern is that this principle isn't that limited, and that if we're going to say anytime the same prosecutor who's investigating a lawyer, it could be for like tax fraud, is also prosecuting a criminal case, then that lawyer has a per se conflict, which might also be unwaivable in your view, which would actually allow a U.S. Attorney's Office to disqualify any defendant's lawyer it wanted to by opening up some unrelated investigation, and that is something I am worried about. So maybe you can address it.
I share that concern. I mean, the worry here is that there's a subject for abuse if the United States attorney can just make up an investigation essentially to get a defense attorney off the case. And I am concerned about that as well. In terms of
Ms. Westover, obviously you would hope that the attorneys would be bound by their oaths and wouldn't make up a frivolous investigation just to get a lawyer off a case. But,
and I'm not saying any prosecutor would do that, but that's
neither am I.
But that is the risk that I would be worried about. There's a possibility for abuse there at least. And I understand that you want a limiting principle, and I agree if it was just the same office, maybe not per se. I'm sure the government's willing to address that, but this is the same office and its conduct related to the underlying investigation. And I really think he's put in a position where he's going to be cross-examining the same people that are prosecuting the defendant on actions that are related to his preparation for that trial. And I do think that that's a hefty conflict.
Ms. Westover, let's assume for the moment that we don't agree with you that the conflict is not waivable. And we also find that the waiver in this case was, the advice given by the district court was insufficient. So then we're left to look at the particular circumstances that you've identified as suggesting that the defense lawyer was pulling his punches. So can you talk about that? Because I'm not so sure that I'm persuaded that those show anything on the record that support your case, but obviously I'm here to be persuaded. So tell me what you think those amount to something here.
Thank you, Your Honor. I want to start out as to calling Ms. Prepera, if I can, Becky Prepera.
Sure.
What I think the objective reasonableness isn't so much an issue as the link, right? I think the link is less intuitive. And what I wanted to make sure I got in today is that to determine if there's a link between not calling Ms. Prepera and the conflict, I think what we should look to is what is the warning that we give defendants when they do waive this conflict? And one of those warnings is your lawyer might pull his punches. Respectfully, I think that presenting a technical defense as opposed to a fact-based defense is one way of pulling punches. And by not calling Ms. Prepera, that's exactly what defense counsel in this case did. Because the only way that Dr. Prepera could get acquitted that I can see in those first cases is if they believe in the first group of counts, the larger group of counts having to do with the false statements, is if they did not believe that he filled out those forms. And by not putting her on the stand, I think that he made a choice to pursue a technical defense. And indeed, during closing argument, the prosecution attorney, when defense counsel tried to argue that Ms. Prepera filled out the forms and not Dr. Prepera, the prosecutor objected and pointed out that defense counsel didn't call Ms. Prepera to testify to that, so there was no evidence.
Ms. Westover, don't we have some indication in the record that had she been called, she would have likely have stood on her Fifth Amendment rights? In fact, that's what happened right during the sentencing hearing?
It did, but that had to do with, we didn't want to let the prosecution practice her cross-examination in his Dr. Prepera's subsequent trial. Dr. Prepera was subsequently indicted on the 841 for an 841 offenses and fraud offenses. And actually that appeal, I should say, was just docketed last week before this court. And Ms. Prepera did testify in that trial. I wasn't present for that trial, so I don't know exactly what she said. But I don't think there's any evidence on the record that Becky Prepera would have taken the Fifth Amendment and not testified in Dr. Prepera's case. And in fact, she filed an affidavit saying that she was prepared to testify and planning on testifying until the day of her testimony.
Does the affidavit say what she would have said?
It says that, I can find it in the record, and it says that she would have said that she was the one that filled out the forms, not Dr. Prepera. It's 3 or 4 pages. I can look it up here in a second and read it to you.
And that he didn't actually read the forms.
And that he didn't read the forms, correct. And I think not calling her, the district court pointed out that Ms. Prepera would have been subject to cross-examination on various topics. I don't think that renders calling her an objectively unreasonable strategy.
So can I ask you, so when she says she filled out the forms, does that suggest or imply that she signed the forms, or that she simply filled them out and then the doctor signed the forms?
What she would have testified to, as I recall the affidavit, is that she filled out the forms for Dr. Prepera. She handed it to him. He signed them without reading them. There is some support for that in the record though it's sort of minimal. It's that she is the one talking to most of the time to employees at Henry Schein when trying to figure out
Okay.
how to order the
So
form.
how does that get him off the hook that he didn't read the form?
Well, if he doesn't read the forms, then he doesn't know there's a falsehood in the forms. So even if he signed them, if he doesn't know what he's signing, it has to be an intentionally misleading fact. So it would be a defense to say, I trusted my wife.
But what about willful blindness?
If he would have to trust, he would have to be trusting his wife for the purpose of evading a crime. I guess that hasn't been briefed by anyone. I guess my answer would be we'd cross that bridge when we came to it. I haven't thought about it before. I mean, before now, but they would have to put in evidence that that's why he wasn't reading the forms. And I don't know what that would be at this point.
Can I
Yes,
ask just
ma'am.
a quick question about the standard of review? In assessing this, the district court relied mostly on, you were about to talk about all the problems that might arise on cross-examination. And the district court says, I'm quoting, having sat through the entirety of the evidence in the trial, the district court thinks it would have been detrimental to the defense to call her. What's our standard of review on that? Because I am sort of moved by the fact that the district court sat through the entirety of the evidence and is making this judgment.
Sure. My understanding is it's a mixed question of law and fact, so it's de novo. But I would also point out she couldn't know, the district court in this case couldn't know or sit through testimony that didn't happen. And here we're talking about whether or not Ms. Prepara testified, and if that put everything in a new light, I'm not sure that the district court would be in a better position to make that judgment. With that, Your Honors, I have 10 seconds left. So unless there are any other questions, I'd ask to reserve the remainder of my time for rebuttal.
Thank you, Ms. Westover. Ms. Rottenborn, whenever you're ready. Did I pronounce your name correctly?
Yes, Your Honor.
Okay, go ahead.
Thank you and good morning. May it please the court. My name is Laura Rottenborn on behalf of the government. As the court knows, this case is about a doctor who lied in order to obtain 10,000 pills and has absolutely no record of where a single one of those pills went. When he was held accountable, he's now trying to escape his conviction by bringing on direct appeal an ineffective assistance of counsel claim that is grounded in an accusation of conflict of interest. But as this court held in Dellinger, the Sixth Amendment does not allow a disappointed client like Prepara to successfully bring such an after-the-fact attack unless he can prove, and it is his burden to prove, that he did not validly waive the conflict and that his attorney actively represented conflicting interests during the trial and as a result made objectively unreasonable trial decisions. Prepara has not carried his burden on any of those factors, and as a result, his Sixth Amendment claim should fail on direct appeal. I'm happy to answer any questions that the panel may have on the conflict of interest. It was the part of the brief that, yes, Your Honor.
I do have a question just even leading up to the conflict. I can't understand how a text from Ms. Kraft to Ms. Castleberry, who was not represented, rises to the level of the government getting phone records from the defense attorney in the first place.
Yes, Your Honor. The government absolutely understands that concern, and it was certainly the subject of the motion for prosecutorial misconduct that Prepara's attorney filed. The same attorney who's now alleged to have a conflict of interest. He pursued that allegation of prosecutorial misconduct even when he knew he had been accused of possible misconduct by the DEA task force officer. And the court held 2 hearings on this issue, multi-hour hearings, the second of which was 3 hours long, to address whether there was indeed prosecutorial misconduct or any type of government misconduct in connection with the administrative subpoena that was issued for Mr. Brownlee's cell phone records. And the court concluded there were not. Just by way of background on what's in the record is that the witness Castleberry had told the federal agents that she felt threatened and intimidated, and then as a result shared the text messages with the agents about alleged interference in Prepara's employees testifying before the grand jury. The task force officer then issued an administrative subpoena. It did not come through the U.S. Attorney's Office. It was not a grand jury subpoena.
How's the defense attorney? Did the defense attorney represent Ms. Kraft? Is that?
No, Your Honor, and that's exactly the problem, is that because Mr. Brownlee was not representing the witness and yet was allegedly encouraging the witness not to testify in the grand jury.
Oh, okay. So Okay, so there is some indication that Mr. Brownlee was encouraging Ms. Kraft to do this?
The text messages refer to John spazzing out that the witness was going into the grand jury room, and particularly going into the grand jury room without representation. And the recipient of that text message then told the federal agent that she had felt, I believed her words were, threatened and intimidated. It's in the
Right,
record and it's in
I
my
guess
brief.
I think we could move on because you were about to say, I think, that the agent hauled off and did this administrative subpoena without any involvement by the U.S. Attorney's Office.
That's correct, Your Honor.
So, okay, then
That
I
is correct.
understand a little more. I thought perhaps the U.S. Attorney's Office had done this, which would be much more problematic for me.
Yes, Your Honor. We agree. It was an unfortunate development for the U.S. Attorney's Office as well, just before trial. And as a result, we had to go through a very lengthy hearing on the morning of trial. We understand that this happened through an administrative subpoena, and we understand the agent's concerns in light of the information that he had received from the witness. The government also immediately informed the court that it would not look at the records, that it would not use the records at trial, and had no intention of in any way misappropriating or misusing that information in the prosecution of Dr. Prepera. The district court judge found that there was no misconduct. That finding was not appealed. The only issue that was appealed.
I want to go on I want to move beyond that. What about the fact that Mrs. Prepera didn't testify?
Yes, Your Honor. That is the primary basis on which Prepera alleges that there was an adverse effect by the attorney's performance as a result of an alleged conflict of interest. And here that allegation simply holds no water. Rebecca Mosig, according to her affidavit, was going to testify that she filled out the forms that Dr. Prepera signed that allowed him to acquire the drugs. Her complicity in his crimes does not exonerate him. And it would not be objectively reasonable to put a wife on the stand who is going to admit to criminal liability without being able to exonerate the client who is being prosecuted. That is not objectively reasonable. All it would do is further confirm that Dr. Prepera had an accomplice to his crimes. It is the doctor who received the drugs. There's no dispute about that. He is the DEA registrant. The only way he can receive the drugs is by submitting the forms to the drug supplier, communicating with that drug supplier, and then receiving the drugs from the drug supplier. He signed the forms. Any allegation that because Rebecca Mosig purportedly helped him out with those forms would only confirm a conspiracy between the two of them, and it would further confirm Dr. Prepera's guilt on the exact offenses charged in the indictment. It would not exonerate him. This is not the case where you had a single perpetrator and one person would be taking responsibility and exonerating another. If Ms. Mosig, who's now Mrs. Prepera, had taken the stand, the jury would have only further confirmed Dr. Prepera's guilt, and that is the exact determination the district court judge made when deciding whether or not the failure to call Ms. Mosig was an objectively unreasonable decision.
Ms. Rottenborn, that's certainly one theory, and not I suppose a somewhat compelling one, but your friend on the other side says that she also would have testified. I'm not sure if she would have testified or someone else would have testified that the doctor signed the forms without reading them, and that as a result, the government would have been hard pressed to show intent. What about that?
I will have to check the affidavit to see if that is specifically stated in Ms. Mosig's affidavit. If it's not, then it's not in the record, and it's Prepera's burden to prove. And so without that, it would be a moot point to begin with. But assuming that specific fact is even in the record, it does not change the fact that in Ms. Mosig's affidavit, which I think it is, it does not change the fact that Dr. Prepera is still obligated, both by Henry Schein, the drug supplier, and by the law, to be the one to submit the forms. And that comes attendant a responsibility to know what those forms say. And the crime is knowingly and intentionally making a material misrepresentation in those forms. The government would have been able to argue that by signing the forms, he read the forms, or if he didn't read the forms, he was willfully choosing not to, which amounts to an intentional violation. And that as a result of submitting those forms, Henry Schein provided Dr. Prepera, not Ms. Mosig, with drugs that they otherwise would not have provided because that information was material to their dispensing decision.
Can I ask a question about that issue of materiality? So as I understand these regulations, the Virginia regulations that were at issue, Um, the regulations prohibited prescribing controlled substances to family members, but the regulations did not prohibit prescribing and or administering controlled substances to friends. That appears to have been permitted under the regulations. So assuming that the standard is objective materiality, if in fact the doctor falsely represented that he intended, or he denied that on the forms that he intended to prescribe and or administer drugs to friends, and the problem here is that the timeline is at some point the doctor was not married to Miss Mosig. Maybe they were engaged, but they were not married. So I suppose they were considered friends during a relevant part of this time period. And if that's true, then why would it have been objectively material to the distributor that the doctor falsely represented that he intended to prescribe and or administer drugs to friends, because that was not unlawful. So you see what I'm getting at here?
Yes, Your Honor.
It's not clear to me what. So go ahead. Why is that material?
I understand the question completely. My opposing counsel will correct me if I'm wrong, but I believe that Dr. Prepera got married in 2014, and the vast majority of these drugs were acquired by Dr. Prepera after the marriage. The April 2014 form, which talks about whether or not Dr. Prepera administers or prescribes drugs to friends, predates the marriage, I think, by a couple of weeks. But my understanding is that the regulations actually change over time as to whether or not friends may be properly given, administered, or prescribed drugs by doctors. And at the time of April 2014, when that first form was submitted to Henry Schein, it was against the law to prescribe to friends under certain circumstances. And so it would still have been material to Henry Schein under the existing regulations in 2014, whether or not Dr. Prepera was administering or prescribing to both family members and friends. I believe the date of the marriage is in my brief, and I was not trial counsel in this case, so I apologize for not remembering it specifically off the top of my head, but I believe it was just a matter of weeks after that first form, and thereafter they were married.
So just so I understand you, you don't think that any of these counts in the indictment are defective based on the relationship and based on the change in the regulations? Because of the change in regulations, those earlier counts dealing with the forms when the couple were not yet married, that still was a violation of the law, and so would have been material?
That's exactly right, Your Honor. And Judge Dillon, the district court judge, addressed this in her memorandum of opinion. I think she uses the word ridiculous, finding it ridiculous to think that Rebecca Mosig would not at least be a friend a couple weeks before their marriage, such that representing to Henry Schein on the purchase form that he was not administering to a friend would strain credulity, because surely they were at least friends just before they got married.
Okay.
Counsel, sorry, can I ask you another question about the Virginia regulations? There seems to be sort of a dispute between the parties about whether they prohibit only prescribing controlled substances or also just, I didn't prescribe anything, I just bought them and gave them to people. What's your understanding of what the regulations prohibit, and does it matter for this case?
It matters in particular for count 69, which is the record-keeping violation. And it only matters tangentially, but there is an exception to when you must keep records, and that exception alleviates a doctor from the obligation of keeping a dispensing log or a required record regarding the pills if he is administering, as opposed to prescribing, controlled substances in the lawful course of professional practice, and he's not charging his patients for those drugs. So under that limited exception, you would not have to keep the dispensing log. Dr. Prepera was not practicing in the lawful course of professional practice. His administration of that.
What was your evidence that he was not practicing in the lawful course of medical practice?
Yes. Well, the government submitted as exhibits the regulations that define what is and is not lawful with respect to the administration of controlled substances to a family member. And then the government also put on the testimony of Dr. Burton, who is a physician from Carillion Clinic here in Roanoke, a large hospital.
But I thought Dr. Burton only testified about professional norms. I mean, the government argued, in fact, against you said Dr. Burton did not give an opinion about the law
That's correct, Your
in
Honor.
one of your other arguments. So how could you rely on Dr. Burton now to basically be giving an opinion about the law?
Oh, you're absolutely right, Your Honor. The district court properly precluded Dr. Burton from drawing any legal conclusion about whether or not administering to your wife for 2.5 years was outside the scope of normal professional practice. But the government did submit the regulations and the law governing this very issue in lieu of having an expert witness draw that legal conclusion. We were all worried about making sure we respected the bounds of an appropriate expert legal opinion. So we submitted the regulations, which the jury then was able to review, and in combination with Dr. Burton's testimony talking about what is standard practice in the industry, it is certainly, the record certainly shows substantial evidence that Dr. Burton was practicing outside the lawful course and was not charging his patients for it, because it has to have both. So Dr. Burton's testimony talks about both Dr. Burton and the witnesses from Prepara's offices talk about the fact that Prepara was not giving these controlled substances to his patients as part of their surgeries, and he was not charging his patients for these medications as part of his surgeries. And all of those things would have to be met in order to satisfy the exception for the record-keeping rule. So it's in the totality. But in terms of the actual lawful course of professional practice, the regulations would speak for themselves, and they were admitted as an exhibit.
But I'm sorry, and I actually am not, it's not clear to me whether it matters to the outcome of this case at all, but the defendant spends a lot of time saying that on their face, the regulation doesn't speak to what the doctor is being charged with here, which is buying the pills and then administering them to someone. It only precludes prescribing controlled substances, writing the prescription and sending the person to a pharmacy, and that didn't happen here. So is that wrong? Is that reading of the regulation incorrect, or does it just not matter?
I don't think it matters, Your Honor. There were multiple regulations submitted, some that governed prescriptions and some that governed administration of controlled substances. With respect to the exception to the record-keeping obligation, that applied only to the administration of controlled substances as relevant to this case. And that would require Dr. Prepara to have administered the controlled substances as part of a lawful course of professional practice. And the jury's verdict implies, if not explicitly states, that his practice here was not lawful with respect to the pills.
But that has nothing, Ms. Rottenberg, but that has nothing to do with whether or not the distributor would have been appropriate for the distributor to have honored the order at the very beginning of the process. If in fact Dr. Prepara could prescribe, could administer drugs to family members, in this case his wife, then why would that have mattered?
Well, the witness from Henry Schein explained that it did matter to them. They asked the question of all of their doctors so that they can then cross-reference the answer to that question with the applicable state regulations. And the Henry Schein employee testified that had Dr. Prepara admitted on that form that he was administering those drugs to his wife, they would not have sent them. That alone is sufficient evidence to convict on counts 1 through 68. It was material to Henry Schein, and that alone is sufficient.
That seems to suggest a subjective materiality standard, because if the law objectively allows the doctor to administer the drugs but not prescribe them, then isn't the distributor imposing a more burdensome requirement than the law imposes?
Theoretically, yes, and that would be absolutely permissible. I mean, a distributor could not provide drugs below the threshold of what the law requires, but if a drug supplier wanted to have more stringent requirements than what the law requires before it distributed drugs to a doctor, it would certainly be in its private right to do so. Here, the key fact is that Henry Schein said that if the doctor said that he was administering the drugs to his wife, they would not have sent the drugs, not only because the law doesn't require it, but because in their view, they wouldn't have done it. And Henry Schein is a private distributor, it's a private retailer, it has every right to decide whether or not it's going to ship drugs to a doctor so long as it's complying with the minimum threshold of the law. 843A3.
Well, again, I'm sorry, I don't want to beat a dead horse, but the standard in this case, the one that the district court instructed on was objective materiality, not subjective materiality. So the fact that the distributor could have, as a matter of whim or just because he was super careful about the distribution of drugs, rejected such an order, that doesn't mean that a reasonable and prudent person, understanding what the rules and regulations required, would have done the same thing. I'm having trouble making that distinction here.
So the material jury instruction that Judge Dillon gave was the traditional instruction on materiality, whether it's a statement that one would reasonably expect to be of concern to a reasonable and prudent person relying upon it. A reasonable drug supplier like Henry Schein, knowing that there are regulations that govern the administration of controlled substances to family members, would find an answer to that question to be of concern. And they would then use that information to cross-reference against the applicable state regulations in deciding whether or not to ship the drugs. And if the drug supplier has concerns about whether or not it's legal, it is absolutely the drug supplier's right to not send the drugs. There's no legal requirement that the drug supplier provide Dr. Para with those drugs. I mean, presumably Henry Schein wishes to make a profit and provide drugs wherever they are legally allowed to do so, but there's no affirmative obligation on the manufacturer to provide drugs if they're uncomfortable providing controlled substances to a doctor. And that Henry Schein here unequivocally stated that had Dr. Para been truthful in responding to those questions, the drug supplier would not have shipped the drugs. And that is all that is required for proving that Dr. Para obtained the drugs by material misrepresentation. I see that my time has almost expired. I'm happy to answer any other questions the panel may have. If not, the government urges the panel to affirm both the convictions and the sentence in this case, and we appreciate your time.
Thank you, Ms. Rottenborn. Ms. Westover, you have some time for rebuttal. I think you're on mute, Ms. Westover.
I'm sorry, Your Honors. I just wanted to quickly address something. I think this is from page 342 of the appendix. The witness from Henry Schein, Mr. Abreu, I believe, testified that the question was important to him, quote, because we would have to adhere to state medical board regulations on treating family and friends. And how do you go about adhering to state medical board regulation on treating family and friends? We would consult the state statute or regulation to determine what the state statute allows or prohibits. And then he says, so if he had checked yes to that question, what would be the next step? We would consult the Virginia regulation on the treatment of family and friends for a controlled substance. And then he said, because people have told me that the Virginia statute prohibits this, we wouldn't have shipped it. But it turned out during the trial, the Virginia statute doesn't prohibit it. And that's why we think it matters on the counts 1 through 68, what that statute says. As to
Counsel, Kate, what can I perhaps spent more time on this Virginia regulation than I should have, but sure. I mean, it's titled treating and prescribing for self and family. The first section says that treating and prescribing have to be based on a bona fide practitioner-patient relationship. And I'm just trying to figure out, why would the rule possibly be that a practitioner can't prescribe a controlled substance for a family member, where at least you have to go to a pharmacy and someone else has to fill the prescription and document it, and there will be a record. But it's fine if he just wants to buy the stuff himself and give it to his wife. Like, it just, when I look at the regulation as a whole, that just seems like sort of an not absurd, but an perhaps slightly counterintuitive reading. And is there like case law on this? If the whole case turns on this, where is the case law? What's going on here?
That's occurred to me too, Your Honor. I would say that in general, it looks to me like there's sort of less that's required for administering, and I'm not a medical professional, and I intuitively don't know why that would be true, but in terms of record keeping and things like that, that seems to be consistent. I can certainly provide supplemental briefing on it. I think for the purpose of this trial, it sort of matters what was presented and what was argued, and the district court seemed to concede that, yeah, the statute only prohibits administering. So, and the expert for the government also sort of conceded the same once it was presented to him. So I think that's sort of what we're left with in this case. The other thing I wanted to quick point out before my time runs out is Becky Prepara in her affidavit, she said, I would have testified that I always provided Frank the forms and he signed them without reading because he trusted that they had been correctly filled out by me. I would have testified that there was never an occasion where I observed Frank to read over the medication order forms personally before executing them with his signature on my assurance to him that they were accurately filled out. In part. Those are the 2 points I wanted to make in rebuttal. So if there are no other questions from the court.
My colleagues have any additional questions?
No.
Okay. Well, thank you very much for your arguments here this morning. The case was ably argued. Traditionally, we would come down from the bench and shake your hands and thank you personally. Obviously, we can't do that, but we're doing so virtually. So accept a virtual handshake from the panel. That's the best we can do under the circumstances, but know that we really appreciate your being here this morning and arguing this case and presenting it to the panel. So thank you very, very much.
Thank you.
Are you all ready? Judge Thacker, Judge Harris, can we move on to the next case?
Yes.
Okay. Well, we'll move on to our second case whenever the U.S. v. Young. Mr. Milling, are you there?
I'm here, Your Honor.
Okay. And let's see. Oh, there we go. Ms. Zomzrek, can you pronounce your name for me? I'm sorry. I can't hear you, ma'am. We can't. You're on mute.
I certainly can, Your Honor. It's Zimmercheck.
Zimmercheck. Thank you very much for that.
Thank you.
And then Mr. Andrews, are you there? I can't hear you, Mr. Andrews. Can you hear us?
Can you hear me now, Your Honor?
I can, yes. Thank you very much.
Okay, thank you.
Okay. All right, Mr. Milling, whenever you're ready.
Thank you. May it please the court, Mr. Andrews. Good morning. My name is Jonathan Milling, and together with Amy Zimmercheck, I'm pleased to represent Mr. Young and Mr. Bolius in this appeal that is brought challenging their convictions here in the district court in South Carolina. It's an interesting factual situation, but I think ultimately this court's determination today is going to depend upon statutory construction and construction specifically of 18 U.S.C. 1716 and what is an explosive. Factually, we've got a situation where my client, Mr. Young, was incarcerated in the South Carolina Department of Corrections for attempting to kill his ex-wife and killing his ex-father-in-law. While he was in the South Carolina Department of Corrections, he gained access to a cell phone and logged into the dark web and started communicating with an individual who he thought was overseas and could manufacture a bomb on his behalf. It was, unbeknownst to Mr. Young, an undercover FBI agent who started a dialogue back and forth about what he would like to have ordered and shipped and where it would go. The item, because it was an FBI agent who was on the other side, Agent McCready, actually constructed this device. He manufactured what was to be an inert bomb, a bomb, according to the testimony, that would not factually explode under any circumstances. And they did that, and I certainly understand and appreciate them doing this to make sure that the public is safe. But when we're looking at how the government chose to charge in this case, they charged count 1 a conspiracy, which is okay. Count 2, they charged transporting explosives. And the definition in that section, 844, is different.
And they didn't charge attempt?
No,
Did not charge attempt.
I
Okay.
don't think that was included. Transport in 844 has included in the definition section, specifically includes high explosives. And that's what Agent McCready indicated that he was trying to do with the block of inert C4. When he put that in there, he started to shave off a parcel of it that he sent off to Agent Parrott for testing. We don't know from the testimony as to whether or not that was taken from what was ultimately placed in the box or the larger block that had a shaving that was put in the box itself. But when we look at 18 USC 1716, which is count 3, that is the definition or the non-mailable items, it does not include a definition of explosives. And so when we start looking at what is an explosive, that's where we get into the statutory construction. And we look at the plain and ordinary meaning of the word explosive. And my colleague from across the aisle, Mr. Andrews, his brief cites to Webster's dictionary, and it says it causes an explosion. It is designed to cause an explosion. What we got here could not, as a matter of fact, have caused an explosion, and the agents testified to that. But what we have to also do, and I've cited in my brief,
Mr. Milling, I thought your colleague on the other side recited a dictionary definition of explosive as an explosive substance or reactive. And if that's true, if we accept that definition, why isn't what was mailed in this case an explosive substance or reactive?
Your Honor, I would submit it would not be considered an explosive substance, or because it could not, based upon the infinitesimal amount that was included in there, could not have caused an explosion. If we look at the Williams case, 2008 Supreme Court case, it says we're supposed to look at, in statutory construction, we need to look at the words surrounding what we've got here. And here the title is Injurious Articles as Non-Mailable. And when we get to the explosive section, it goes through all explosives, hazardous materials, inflammable materials, infernal machines, and mechanical, chemical, or other devices or compositions which may ignite or explode. And so it's clear from that. Yes, Your Honor.
Yeah, but the FBI agent also testified that it contained all of the essential pieces of a fully functional improvised exploding device. What about that?
Except for the fact that it did not have the necessary explosive capabilities in either the detonator, as I recall, or the actual C4 block of C4. It did not have the capability of being able to explode. And I think my colleague, Ms. Zimmercheck, actually in closing argument, destroyed the device there in the courtroom, and there was no explosion because it was in fact a safe device. And again, I understand why the law enforcement did this way, because they want to make sure that it was safe. But if we're looking at the intent behind that statute and reading these words together, the whole purpose behind it is to make sure that whatever is being sent through the mails does not have the potential for harming the public. And that's why it's
Mr. Milling, can I follow up? Go ahead, Judge Thacker.
No, you go ahead, Judge Diaz.
Thank you. Just following up on that. So the statute talks about all explosives, right? And under your reading of the statute, what is to prevent someone who is bound and determined to violate the law to send sort of de minimis amounts of explosives in separate packages, each one of which, under your definition, would not amount to a violation of the law, but then gather up all those substances at the receiving end and put together an explosive device? That seems to me a very difficult interpretation of the statute to accept.
Well, and Your Honor, I would submit that would be a violation of the law, because you've got the criminal conspiracy, which our clients were charged in count 1 with. It's just whether or not this particular parcel by itself was a violation of the statute, whether or not it contained a non-mailable material. And that's where we have to look, in my opinion, at the definition here of explosive, and whether or not this particular item, as it was submitted through the mails, would have been a violation of the statute. Certainly, we've got other things.
If the government would have charged attempt, would you have the same argument?
With an attempt, I think that it certainly is a different argument. I think that it's very difficult if he intended to do that. I think the attempt would be problematic for us with regards to this particular argument. Here, I think that this is a scenario where the government, as kids, we called it piling on or dogpiling, where you've already got the charge and you just continue to add on top of it. We've got a conspiracy conviction. We've got the transportation conviction, and the government, being a little bit overzealous, in my opinion, in this case, started to charge additional charges, which just did not meet with the facts of the case. Beyond that, and we talked about this earlier a little bit, the government did not test the parcel afterwards. And so when we're looking at whether or not the item that was actually mailed by my clients, which is the crux of 1716, whether or not that in fact contained any of the high explosives, as Mr. Parrott testified, was present in what he actually tested. And so when we look at that, there's no evidence to suggest that what was actually sent, what the box, the hoax bomb, if you will, actually contained any high explosives in it. The C4 block that was originally sampled does, according to the testimony of Mr. Parrott. But when we're looking at what was actually presented at trial, we don't know what was actually contained within that parcel itself. Now, beyond that, when we're looking at really the meat and potatoes of what we've got here, when we shift over to count four specifically attaches to the count 3 conviction and the 1716 conviction as the any other felony. And Mr. Andrews, in his brief in footnote 9 on page 29, they concede that if this item, if count 3 is legally insufficient, then count 4 also is legally insufficient, because that was the bridge, if you will, between the two convictions. And that's important here because that is a 120-month consecutive sentence. My client's guideline range before we got there was 324 to 405 months. When you add that on top, we end up with a 525-month sentence, which is a significant sentence, and it does make a difference as to whether or not we've got a consecutive 10 years on top of it. There have been very few cases that have interpreted the explosive portion of 1716. We've got the Wisdom case from the 8th Circuit that we have cited, and we've got the Hamrick case from this circuit that we've cited in our briefs. And in each of those cases, there were other flammable materials which were able to give rise to the convictions at issue in this case.
Mr. Millen, can I ask another question? So under your theory of the case, would this interpretation of the statute put a very difficult burden on postal workers to decide what is an acceptable level of an explosive to allow to be transmitted through the mails?
I think that it places the burden on Congress to go back and actually define an explosive like they did in 841 and 844. I think that ultimately is the decision. I think that the postal workers can certainly turn any items that they have concerns over to law enforcement for investigation. I think that they would do that anyway, but where we have a situation here is ultimately in the charging decision by the U.S. Attorney's Office, and there were other charges that could and were properly brought. Thank you, Your Honors.
Thank you, Mr. Millen. You've got some time reserved for rebuttal. Ms. Zimmercheck.
Thank you, Your Honors. May it please the court. Amy Zimmercheck. Along with joining that first argument, Mr. Volius has a few separate arguments, and those are the ones I'm going to focus on. They primarily deal with the conspiracy and the request for multiple conspiracies. There were several motions filed by Mr. Volius to separate. So the general conspiracy was under 371, which is the defraud conspiracy. However, and it's clear this operation was named Operation Boombox. It is clear that the focus of the government in this case was this fake mail bomb. And then as an aside, or as maybe a way to loop Mr. Volius in, they added Section D under the 371 when they were identifying the conspiracy, which is the drug conspiracy. The brief that was submitted by the government states that it was a general overall conspiracy, and even though the substantive counts didn't even address the drugs, this is a unique case, as the co-defendant, Mr. Young, got up on the stand and actually provided direct testimony of two conspiracies. He said there was the drug conspiracy where they were mailing drugs back and forth to each other, but then there was also the completely separate bomb conspiracy. And in that, so we first argue that there was a fatal variance. Because of that just significant difference in the drug compared to the remainder of the conspiracy. But even so, we would ask that that this court find that the failure to give the multiple conspiracies count, especially in light of the testimony in this case, not only just from Mr. Young, who provided direct testimony that Mr. Volius had nothing to do with this fake mail bomb, and that he only asked him to print a label that didn't even have the intended recipient's name on it, so it wasn't a way for Mr. Volius to recognize that the intended recipient had been married and received a new name, and so there was no way for him to know.
Ms. Zimmercheck, can I ask about that? So I get your point that you think that the evidence is disputed with respect to your client's involvement in the bomb plot, but wasn't that a jury question? And how does the instruction on a separate conspiracy help you in terms of having the jury sort that out?
So what that does is in this case, and that kind of, to answer that, Your Honor, it folds into our third as well, our third issue, which is the severance of either the defendant or the count. But how that helps, Your Honor, is when a jury is provided an instruction on multiple conspiracies, then they are asked, given the facts as presented to you through the case agent, through the testimony of Mr. Young, here's your duty as a jury. If you may find that there are two conspiracies. If you find that there are two conspiracies, but only charged one, then you must find not guilty. If the two conspiracies are not identified in the overall charge, and
so can I ask? So I'm sorry. With respect to that, I mean, there was no dispute, obviously, that your client participated in the drug ring, right? He's kind of admitted that. So then the jury was simply left to decide whether or not he also participated in this admittedly unrelated plot to kill the wife of the other defendant. That doesn't seem to me to be an overly complicated thing for the jury to sort out on this record and these facts. So it would have been better to give a separate instruction, but the question is whether or not that was harmless on these facts, assuming that one was required.
And we argue, Your Honor, that it was not harmless. There was, and again, it flows into our third argument about the severance, but there was the first few days of testimony, quite honestly, dealt primarily with this bomb plot. And it talked about the past of Mr. Young, the co-defendant who had killed someone. All of this was done without having anything to do with Mr. Volius. For a jury to have to take the instruction as it was received, which is the instruction as it was received is, if you can find a conspiracy amongst any of these, A, B, C, or D, and then that's where it becomes not harmless, because and I see that my time is finished, if I may continue.
You can go ahead. Yes, go ahead.
I just have a quick
Judge Harris
follow-up,
also has a
too.
question, so go ahead.
Okay.
Yeah.
And I'll finish that and get to Judge Harris. I'm sorry, but admittedly, if he wasn't involved in D, if he was only involved in D, as the evidence suggests, the jury instruction would have provided clarity as to his overall involvement, which I think they would have then been able to consider and weigh against the evidence of whether or not he should be guilty of that charge.
Okay, so
Yes,
this
Judge
goes directly to my question, and I think maybe I'm misunderstanding something, but even if the jury had found he was only involved in D, shouldn't it have convicted on the conspiracy count? I mean, I thought the fact that one conspirator isn't involved in all of the conspiracy's activities doesn't mean there's more than one conspiracy. And given that the drug distribution was charged as an object, if the jury had found, yes, he's involved in the drug distribution with these other guys, weren't they supposed to convict under count one or
Well,
not?
as the jury instruction read. However, if they would have been provided that jury instruction about, go ahead. I'm sorry.
But even if they had been instructed that, I thought the normal instruction was, look, you can't convict him under count one just because you find that he's involved in some separate conspiracy. That's not enough to convict him on count one. But if they found that the conspiracy he was involved in was the drug distribution conspiracy with all these same people, given that drug distribution is listed as an object of the general conspiracy, why isn't that enough to convict under the general conspiracy?
Right, right. And so that was that was the issue that we faced, because we felt like the reason that if they had been provided the jury instruction, then I don't think that they could have found him guilty under that. Yes, it was charged, although not substantive, there wasn't a substantive count. It was charged in the general conspiracy, Judge. That when you have to go back to look at the general conspiracy. It's not just the same actors, and what we're missing here is the same objective, the same goal, and that's where the issue, finding a fatal variance that's why we argued the fatal variance to begin with. But even if one weren't found, that's why we would argue the multiple conspiracy, because the problem is that they did not have the same objective, the same goal, and that was the argument. Even though there were same actors involved, they were certainly not. All of their actions in the two different conspiracies did not go towards one common goal.
Okay.
All right, thank you, counsel. Mr. Andrews, we'll hear from you.
Thank you, Your Honor, and may it please the court. Your Honor, in Section 1716, Congress prohibited the mailing of both all explosives as well as devices which may explode. The package that appellants conspired to place into the United States mail to be sent to Shauna Clark did include explosives known as RDX and HDX, which, as the government's expert testified at trial, has no other use than to cause an explosion.
But it was designed specifically not to explode, wasn't it?
That's correct. The device itself, so the package was designed not to explode. That does not make it such that the explosives within it are no longer explosives. And so, Judge Thacker...
But so how is it a device? How is it then a device which may ignite or explode?
Well, Your Honor, our argument would be that it is an explosive, that it's not necessarily a device that may or may not explode, and that those are separate pieces of that single provision. And in fact, the primary mistake that the appellant's argument makes is to conflate those two, such to the point where the second, or rather the first, would be rendered superfluous. If we interpret the term all explosives to also mean all explosive devices, then the language of the second provision and the first are effectively the same. Rather, we think the plain language of the statute, when we look at the definition in the dictionary, which, as we've discussed, is a substance that may be used to cause an explosion. Certainly, I don't think anyone contests that RDX and HDX are substances that may be used to cause an explosion. It's our position that these are categorically explosive substances. And that reading of the statute is confirmed as well by the usage of the only explosives experts to testify in this case, who discussed RDX and HDX and referred to them specifically as categorically high explosives. Now, it may be that any of these explosives in any particular compound may not be enough to actually create an explosion, but our view is that that's not what the statute requires. Take, for example, the instance of sugar. Sugar is categorically a sweetener, but if you were just to drop a pinch of sugar in a large mix of batter, it may not make that batter sweet. So, if you have RDX in this compound, it's not going to make it an explosive device, but it doesn't change the fundamental nature of RDX, which is that it is defined as an explosive and is considered an explosive. I'll point out as well that although this particular statute doesn't include a definition of explosive, this reading of the statute is consistent with the definition that's provided in 18 U.S.C. 844, which prohibits powders that may be used as for blasting purposes. So RDX and HDX are certainly explosives, even if this was a non-explodable device. And in our view, that's all the statute requires. I've discussed the plain language, the rule against superfluity. I would also mention that the appellant's construction, despite their discussion of public health and safety, really undermines the public policy goals of health and human safety. As Judge Diaz rightly pointed out, surely it can't be that Congress intended people at home to be determining what amount of RDX, HDX, or TNT is an appropriate, safe amount to place into a package as it goes into the mails. In fact, rather, we think that the more natural reading of the statute is that Congress simply intended to prohibit, to draw a bright line rule that no one should be mailing RDX, HDX, or other explosive chemicals or compounds. Many of these compounds tend to be highly volatile. When placed in the United States mails under one condition, you don't know if that condition will change upon mailing, and so
Mr. Andrews, can I ask about that as a follow-up? Just Thacker mentioned this to your colleagues when they argued. So do you, there would have been nothing to prevent the government from charging an attempt in this case. Is that right?
That's correct, Your Honor.
So, and I suppose the government could have simply inserted in the package sugar, to use your example, as opposed to a finite or small amount of explosives. And so long as the defendants had the intent to commit the offense, they could have been charged under the attempt statute, right?
That's correct, Your Honor.
Okay. So the reason I asked that is I suppose there's nothing to prevent the government from charging the case the way it did. But I was concerned, frankly, that there was some evidence in the record, and you just mentioned this, that even a small amount of explosives sent through the mails could change their condition and explode. So I wasn't sure why the government felt it appropriate to send, even a small amount of explosives through the mail, because even that amount, it seems to me, had some level of potential for a difficult result.
Well, Your Honor, I can't speak with certainty, but I would imagine the view was that that's what the statute requires. It does require that for it to be a non-mailable item, it would need to include an explosive. And to come back to the public safety concern, I mean, obviously,
I'm sorry, counsel. Counsel, can I just stop you there? I feel like that didn't quite answer the question. That sort of presumes, well, we have to charge a completed offense under this statute. But I thought the question was, and I agree, if that's your starting point, you better put some explosives in the mail. But why did the government, given the risks, make that charging decision? I think was the question.
Right. Thank you, Judge Harris. And I
a much
apologize
better framed question than the one I gave you.
Candidly, Your Honor, I cannot answer with certainty why the government chose to make one charging decision or another. But to the risks that you mentioned, I would point out that this device was constructed by experts at the FBI who satisfied themselves that this was incapable of causing injury to any of the targets in this case or any of the investigators. And it did not, in fact, travel through the mail. We believe, for the purposes of the statute, it was placed in the mails. Mr. Fears deposited it at a mailing location, but then it was immediately picked up by law enforcement officers. And so it did not, travel on a bus or an airplane or anything like that. So we don't have any disagreement. In fact, we concede that the package was not going to explode. The primary difference between our view and theirs in this particular case is whether just the existence of these categorically explosive materials was in violation of the statute, and we believe that that's the plainest reading of the statute itself. I'll point out another piece about the language in this statute as well. If you look at this particular paragraph, you can see that it prohibits a long list of different types of articles and materials. Prefacing each one of these independent clauses is the word all. And what you see is in 1716A, there is a broad prohibition on a number of different categories of potentially hazardous articles and materials. And then below that is a list of specific objections. And so, for instance, at the very top, if we look at poison, the statute bans poison and mixtures containing poison. Now, it doesn't identify a particular concentration of poison. There is no information in the statute that tells us how much poison is allowable or how much poison is not allowable. And I think that the fair reading there is that no poison is allowable, just as this fair reading is that people should not be sending RDX, HDX to one another in any amount. I would point out as well, poisonous animals. I think a fair reading of the statute is that no one should be mailing rattlesnakes to one another, full stop. And that would be the case even if a snake, for whatever reason, had been drained of its venom, or perhaps some type of disorder where it did not produce poisonous venom. I think the best reading here is that the United States Postal Service does not want people mailing poisonous animals of any kind. And if one were to look for an exception, it would be below, where you see that scorpions are mailable for certain medical purposes. And so we know that where Congress creates exceptions and where we start with a broad prohibition of different categories, that we shouldn't be reading additional exceptions into the statute. One last point I'll make on this before I turn to the conspiracy issues, if there's no other questions, is that in the immediately preceding subsection, or rather section, which is section 1715, Congress also outlaws the mailing of handguns, pistols, revolvers, other concealable weapons. It doesn't just outlaw the mailing of loaded guns or unlocked guns. It prohibits the mailing of all types of guns, whether they're loaded or unloaded. And as we all know, an unloaded firearm can't fire a bullet. So with that, I'll turn to the conspiracy issues, if there's no further questions on the explosion piece. As to the appellant's arguments regarding the conspiracy, I think that they only make sense if the court disregards the evidence in the record that Vance Vollius did, in fact, participate in the plot to mail a bomb to Shauna Clark. The entire argument about there being a variance rests on the premise that the evidence at trial doesn't line up with the facts as alleged in the indictment. But the facts as alleged in the indictment, specifically the overt acts that Mr. Vollius was alleged to have participated in furtherance of the conspiracy, are that he received shipping labels for the bomb from Mr. Young, that Young and Vollius spoke on the phone about the shipping labels. We saw Mr. Meredith's testimony at trial regarding that, as well as text messages introduced between Mr. Meredith and Mr. Young, indicating that he had been speaking with Vollius about the labels and the bomb. And additionally, that we know from Mr. Fear's testimony that Vollius, in fact, provided the shipping labels for the bomb to Mr. Fears at Mr. Fear's house, at which point they had a conversation about the target of the bomb, Ms. Clark. Mr. Vollius indicated that he knew it was going there, and he indicated he did not want his fingerprints on those shipping labels. So that's the evidence that the jury heard. It's also exactly the allegations that are in the indictment. And through the testimony of Meredith and Fears, the jury also heard about the connection between the drug conspiracy and the conspiracy to send a mail bomb to Ms. Clark. We have the overlapping actors here, and we have the overlapping methods. And the goal was to continue the criminal enterprise and to enrich themselves. What you see is that Mr. Young had created a drug distribution network that gave him hands on the outside world. Mr. Young, of course, was incarcerated, but Mr. Vollius, Mr. Fears, and Mr. Meredith each played a role in serving him on the outside of the prison. And in return, Mr. Vollius, Mr. Fears, and Mr. Meredith received from Young a source of drugs, a very large amount of drugs, I might add, and money, a steady flow of income and drugs for each of their purposes. And so there was a natural relationship here, and the bomb plot would not have been possible without the foundation and the framework that the drug conspiracy built.
Let me ask, go ahead, Judge Harris.
No, you go, Judge Diaz, go first.
So if in fact there had been no evidence that Mr. Vollius had any inkling about the bomb plot or been involved in any way in the bomb plot, is it the government's contention that he nonetheless would have been on the hook as a conspirator for what would have been a completely unrelated crime? And if so, how?
No, Your Honor. The government bears the burden of establishing beyond a reasonable doubt every object of the conspiracy in this case, and we did that. In fact, if the court were to look at the last 3 pages of the supplemental joint appendix, you will see the special verdict form from the jury in this case for Mr. Vollius, where the jury found not only each count guilty, but each individual object of the conspiracy they independently appraised and found him guilty of as well. If for some reason they had said, they'd looked at the evidence and they found him not to be guilty of one of the objects, I think they certainly would have understood that. In the cases that this court has evaluated, I look back to Kennedy, for instance, in which, and Judge Diaz, I believe you alluded to this earlier in one of your questions to the appellant, but even if there is a variance, the question of whether it's a fatal variance is one that requires a demonstration of actual prejudice. And what this court said in Kennedy is that it's very hard to do that unless there are so many defendants and so many potential conspiracies that the jury is going to be overwhelmed or confused, or more likely to confuse evidence of one conspiracy with another. In Kennedy, there were 8 defendants and 3 conspiracies. Here we're talking about 2 defendants and 2 conspiracies. So that chance and that risk of confusing evidence in one conspiracy for another, and for the defendant being painted unfairly with that brush was very low here. If we had charged these conspiracies separately, there's no indication in the record it would have made any difference. The same witnesses would have been called with the same evidence. And this is true, by the way, even if the cases were severed. We still would have had the testimony from Mr. Fears, still would have had the testimony from Mr. Meredith. All of the same evidence would have been there, and all of the same inferences and conclusions would have been able to be drawn from the jury.
I'm sorry, this is Judge Harris. Can I ask you just to go back? I didn't catch what you said at the end of your answer to Judge Diaz's question. The special verdict forms here show that the jury found the defendant guilty on all 4 of the objects, but what would have happened if the jury had only checked the drug distribution one, in your view?
In my view, and I think Griffin from the United States
what is the
Supreme Court
government's position? Yeah.
Our position is that he would be guilty for the count, for count 1 for sure. He'd be guilty of the conspiracy. Now,
Okay.
I think, in terms of which objects he is guilty for, that may come into play at sentencing. It would not change his guilt on the ultimate count, and I think that's fairly well established.
Okay.
And so I'll just one quick point about the multiple conspiracy charge. I think it fares the same way as the fatal variance analysis, but also like the fatal variance analysis, we still have to look for, even if the charge should have been made, and I think that the standard has been articulated by this court in Kennedy as well as Nunez and Squillicote, that multiple conspiracy instruction is not required unless the proof at trial shows appellants were involved only in a separate conspiracy. But even in assuming that a charge was required, it's only reversed upon a showing of substantial prejudice, which this court has said requires that the jury probably would have acquitted without that instruction. And again, our position would be there's just no reason to believe that would be the case, given the substantial evidence that supports Mr. Vollius's conviction. And I have a little bit of time left on the clock. I'm happy to answer any further questions that the court may have.
I just am having trouble wrapping my mind around some of this conspiracy stuff. Just your last sentence that given the substantial evidence supporting his conviction, do you mean given that there's substantial evidence supporting that he was involved in the bomb plot? Or is your argument the same if there were only substantial evidence that he was involved in drug distribution, which was charged as an object of the conspiracy? Which do you mean?
Thank you, Your Honor. Both, all of the above. I was specifically talking about the bomb plot because I don't believe that the drug plot is at issue. I think, in fact, they have conceded that he did, in fact, conspire to sell drugs. That issue is certainly enough to get a guilty verdict, to sustain a guilty verdict as to count 1. But this question of the bomb plot, which they have raised and primarily is the focus of their concern, And I think the focus of, at least their suggestion that there's not sufficient evidence in the record to support Vollius's connection to it, my assertion about the substantial evidence really extends to the bomb plot.
Okay. And my only other question is, we talked about the single versus multiple conspiracy and the overlap of actors and methods. And then when we got to goals, you were talking at a pretty high level of generality about, well, I mean, I can't quite remember what it was, but just kind of keep the criminal stuff moving. I mean, do we have cases that look a lot like this one where the two objects of the conspiracy are so different from each other? I feel just in sort of, I haven't done a detailed accounting, but it seems like most often it's like, well, they're dealing drugs in place A, but they're also dealing drugs in place B, so it's one conspiracy. I mean, these seem quite divergent, a bomb versus drugs. And the bomb has nothing to do with the drug conspiracy. It's not that they're trying to take out a competing drug supplier or something.
Your Honor, I don't have a great illustrative case on point, but I would refer you to, there's a case called United States versus Stewart, and I apologize, I'm not sure if it's in our briefing. It's one I came across in preparation for argument. And in United States versus Stewart, which is from this court in 2001, the court talks about the term interdependence in the course of evaluating a conspiracy. And this concept of interdependence is that, if there's actions on one part of the scheme, and Your Honor, I see that I'm out of time, if I may.
You can go ahead. Go ahead, Mr. Andrews. Finish your answer.
If there is an action on in one part of the scheme that is that is necessary to further some other action of the scheme, or that is necessary for the entire scheme to be successful, then those two are interdependent. And so I do think that this concept of interdependence is important here. I don't believe that Young would have had the resources to put together a bomb plot if he had not been mailing and distributing illegal drugs with the help of these people for the preceding 6 months. When he wanted to try to kill his ex-wife for the second time, he knew exactly who he could turn to and exactly who he could trust. And if there's no further questions, thank you.
Thank you, Mr. Andrews. Mr. Milling, you have some time for rebuttal.
Thank you, Your Honors. May it please the court. And I guess I'd like to start with really where Mr. Andrews started, talking about the language in 1716 and his reference to appellants' reading of that statute, rendering certain language and certain phrases superfluous. As I read this, I see a list of a series of different non-mailable items that all may ignite or explode. And then we get to the end, which is a catch-all. And that's where it reads, or other compositions which might ignite or explode, which shows the overall concern of this as being mailing of items that might be injurious. I don't know if Mr. Andrews has any children or not. I've got 4 kids. And as I'm trying to explain to them what to do and what not to do, I've learned you've got to put that catch-all in there in telling them what not to do, or they're going to come back and say, well, you didn't specifically tell me not to do that. And so that's where Congress, I think, was coming in and defining this statute. It lists a series of things that might ignite or explode on their own, and then we've got a catch-all phrase which says, or anything else that might explode. When we look at the first part that Mr. Andrews also pointed to, poison and articles of composition containing poison in all poisonous animals or insects. What I think we've got here is a situation where we're not suggesting that we're going to send a rattlesnake through the mails that doesn't have any venom in it, but rather, according to Mr. Andrews, this would also criminalize the mailing of a rattle off of the back of a rattlesnake, which has no poisonous properties at all. And so where we are here is, likewise with the prohibition of mailing guns. Guns are made out of metal. You can mail metal through the Postal Service, which could ultimately be used to create a firearm. But where we're I think having a problem here is when he talks about putting sugar in there. If the statute says you can't mail a cake and the cake doesn't have sugar in it, is it in fact the cake? And the testimony, and I pulled it from my brief while he was talking, Joint Appendix pages starting on page 525, Agent McCready gives pretty clear testimony, contrary to what Mr. Andrews talks about as far as this being an item that could have changed during the mails and become explosive. Agent McCready says this was not going to explode. This was safe, and that's why we set it up the way that we set it up. It's not going to explode. And I alluded to this earlier with Ms. Zimmercheck's closing argument as to how she destroyed the item there in the courtroom, and it did not, in fact, explode. We've got a statute which does not have
what about the beginning part where it just says, and all explosives, hazardous materials, blah, blah. It just says, and all explosives. It doesn't connect it with the may ignite or explode. That's a different clause that starts with a separate and.
Yes, Your Honor, and I think that when we're looking at when it says explosives, that's what we have to look at, because there's no definition. What is the explosive? And that's where Congress in other statutes has defined explosives to include the presence of high explosives. But they didn't do that here. And I think that when we're looking at statutory construction, when Congress has clearly expressed the ability to define a word like they did in 844 when they defined it a certain way, in 841, they don't define it here. And so we have to use the common and ordinary meaning and using it in context within this particular statute. And that's where yes, Judge Harris.
I'm sorry, so counsel, I want to make sure I'm clear. How much of your argument depends on the existence of this clause in the statute that says other devices or compositions which may ignite or explode? Is your argument now that take that out, even if it didn't include that, you would be arguing this was not an explosive?
Yes, Your Honor.
Okay, so you don't need that last clause. Forget the last clause.
Correct. Basically, the portion of, I mean, it is clear that this device, this box, this parcel was not going to explode. The first portion, whether or not it included explosives itself, because explosives is not a defined term, we have to look at it in context within that particular statute in discerning whether or not what is there. Yes, sir.
Mr. Milling, I'm now a little bit confused. I thought you said that the catch-all was important, and you used the example of your kids. Your kids
Yes,
need a
sir.
catch-all. And by the way, I tried that catch-all with my kids, and they don't work. So, so which one is it? Is it important? Yeah, okay. Does it matter or doesn't?
I think that phrase is a catch-all, which it helps us interpret what is the meaning of explosives. It is a separate way that can, in fact, violate the statute. I think that it is useful and helpful in discerning exactly what Congress's intent was. I think that it is helpful in determining exactly what context an explosive is when used in this statute. And there, our position is explosive means it has to be able to ignite or explode because we're using it in context and injure people if it's actually submitted in the mails.
Okay, thank you.
Thank you, Your Honor.
All right, thank you very much. The case has been ably argued. I want to thank all three lawyers for their presentations here this morning. We would typically come down from the bench and greet you personally. Obviously, we cannot do that, but please know that we are grateful to you for helping us with this interesting and difficult case. And Ms. Zimchek and Mr. Milling, in particular, I want to thank you both because you are both court appointed. And we could not do the important work that we do without lawyers who are willing to take on cases. As court-appointed counsel, you ably discharged those duties here today, as did Mr. Andrews on behalf of the government. So thank you very much, and please be careful and stay safe. Thank you very much.
Thank you, Your Honor.
Thank you.
Judges, do you want to take a break? Or are you ready to continue? Ms. Lyson, are you able to hear us?
Yes, Your Honor.
Okay,
you-
Mr. Bragdon, I just want to check to see if can you still hear us? Okay.
Yes.
I can hear you just fine.
Okay, great. All right, Ms. Lyson, I'm sorry, we'll hear from you.
Thank you, Your Honors. May it please the court, Jenny Lyston for Christopher Singletary. Your Honors, the written judgment in this case imposing special conditions for supervised release is erroneous and must be vacated for at least 3 reasons. First, the written judgment conflicts with the oral pronouncement of sentence. Second, the district court plainly erred in failing to explain why the special conditions of supervision were necessary or appropriate in Mr. Singletary's case. And third, we believe that one of the conditions impermissibly delegates judicial authority to the probation officer. So first, turning to the first argument.
Counsel, can I just ask you a quick question sort of about the order of operations for us here? Assuming for a minute that there's no appeal waiver problem. If you're right on your Rogers claim, and I think the government on the merits assumes that you are, that there's an inconsistent judgment here, then we would vacate the sentence and remand for resentencing under Rogers, so we would never get to the other 2 issues, right?
I believe that's correct, Your Honor. So
Okay.
I think if you decide that if you simply don't think the appellate waiver applies here, you would send it back for a resentencing on the conditions of supervised release, and you would not need to reach the other issues, correct?
Right, it's a full resentencing. We vacate the entire sentence and send it back. I mean, excuse me, I should be careful. I'm not trying to suggest what form the resentencing takes, but the relief in Rogers was the sentence is gone. This person has no longer been sentenced.
Absolutely, we agree. And then
Okay.
on remand, then counsel Mr. Singletary would have the opportunity to explain to the court why those financial conditions were not necessary and appropriate in this case. That's correct.
Right, it would have the benefit of allowing the defendant to object at the oral sentencing, right?
Exactly, Your Honor. So Judge Harris, we agree with you absolutely that it is the written judgment is erroneous because it imposes those 2 conditions that were never announced at sentencing. So applying that de novo standard in Rogers and comparing the written judgment, which those 2 conditions appear on JA 82, to the oral pronouncement of sentence, which is at 73 and 74 of the JA, it's clear that the district court never announced those 2 financial conditions of supervision. And as we know, under Federal Rule 35C, the oral pronouncement of sentence is the controlling sentence. And so this court has said in Rogers and Osborne and Morse and Doswell and those cases that we cited, that where there is a conflict between the oral pronouncement of sentence and the written judgment, the oral pronouncement controls. Those conditions, those 2 conditions are effectively nullities and must be stricken. Yes, Judge Thacker.
But that doesn't make it an illegal sentence, does it, that would get you past the waiver in the plea agreement?
So
the waiver of appealing the sentence?
So, Your Honor, we don't believe that the plea waiver does bar Mr. Singletary's claim here for a couple of reasons. So first, this court could simply decline to enforce the plea waiver, which we've asked for, which it did under identical circumstances in United States versus Hargrave. This court said that at this late juncture, we declined to enforce the plea waiver. In Hargrave, the defendant pled guilty pursuant to a plea agreement to 1 count of Hobbs Act robbery, 1 924C count. In both cases, there was a plea agreement. Counsel for the defendant filed an Andrews brief specifically citing the plea waiver. In both cases, the government didn't. Yes, Judge Thacker.
No, maybe the government didn't raise it in Hargrave, but here in response to the Andrews brief, the government said, we're not going to file a brief at this time unless the court orders us to do so, but we reserve the right to stand on the waiver. They did raise it in response to the Andrews brief.
And so, Your Honors, if you do not want to follow Hargrave, which is an unpublished decision, then
I didn't say I wasn't following Hargrave. I'm saying this case is different from Hargrave.
I understand, Your Honor. So we don't think necessarily then that these issues would fall outside of the plea waiver. And I would point to And I'm talking here about the two conditions that were imposed outside of Mr. Singletary's presence. And I think that this court's decision in United States versus the TAR, which we cited in our response to the motion, government's motion to dismiss, is particularly instructive in this case. That was an appeal from the Eastern District of North Carolina, so it involved the exact same appeal waiver that we have in this case. And in a TAR, the defendant brought a challenge sought to appeal his sentence after his attorneys were permitted at sentencing at the beginning of the sentencing proceeding, and then he had to proceed with that sentencing without counsel. And he challenged that under Sixth Amendment on appeal. The defendant, the government sought to dismiss that case, that appeal. And this court said that we do not think the general waiver of appeals rights contained in this plea agreement can really be construed as a waiver of the right to challenge their sentences on that basis. Because implicit in the defendant's agreement to waive appellate review of his sentence is implicitly conditioned on the assumption that the proceedings following entry of the plea will be conducted in accordance with constitutional limitations. And we think that's essentially what we have here. The district court went off and imposed special conditions of supervision outside of Mr. Singletary's presence, outside of his counsel's presence. He had no opportunity to object. And so we just don't think that kind of issue, that sort of fundamental issue, is something that is contemplated in the plea agreement. And if you think about
Ms. Lyston, could I ask a question about the conditions here? So is there a legitimate distinction to be made between those conditions that the district court was empowered to require in this case, and a separate condition, for example, the one where arguably the district court delegated its authority to enter a condition with respect to the financial restrictions that were placed on your client? So in the former, it would seem to me that if there's a waiver, a valid waiver, then sort of forfeited the right to object to those because they were otherwise valid conditions entered irregularly. And the latter, though, it seems to me you have a better argument that if the district court went beyond its authority to delegate its power to impose punishment, that can't be waived. So what about that distinction?
So I'm sorry, Your Honor. Are you talking about mandatory conditions of supervision or
I don't know that it matters. I guess what I'm asking is whether a district court who has the authority to impose conditions but does so in a regular fashion, whether that mistake or error is waived by a valid plea waiver as opposed to the delegation of authority to impose conditions with respect to the financial issues that opening up the account, for example. In this case, the district court apparently delegated that authority to a probation officer. And so I think there's a distinction to be made between that condition and the others where it's simply the district court simply entered those conditions without giving your client an opportunity to respond.
So, Your Honor, so I don't think the court actually has any authority, and we're talking about the same condition here, and just to be clear, this is on...
Yeah, so tell me, so identify the conditions for me, so you have them in front of you.
I apologize, Your Honor. So those two conditions are the defendant shall not incur new credit charges or open additional lines of credit without approval of the probation office. And the second one is the defendant shall provide the probation office with access to any requested financial information. We don't think the district court has any authority to, after it has orally pronounced the sentence, to go back and alter the written judgment to add additional conditions of supervised release after the fact, outside of the presence of the defendant or his counsel. Yes, Your Honor.
Counsel, maybe this is semantic, but I feel like under Rogers, that's not exactly your argument. Under Rogers, your argument is these conditions were literally never imposed. They are not part of his sentence. He's not challenging his sentence. He's not challenging the irregular imposition of certain conditions as part of his sentence. He literally has not been sentenced to those conditions.
Absolutely. That is my argument, Your Honor. So we contend that those conditions are just void and must be stricken. Now, if this court goes ahead and under Rogers and decides that that is also the sentence is plainly unreasonable because the district court didn't explain its reasons for imposing any of these conditions, then the whole thing would get a remand and there'd be resentencing. If you decide that only those two conditions that were imposed outside of his presence that actually weren't imposed, we say
Right.
the actual sentence is the one, the oral pronouncement of sentence, then we think it would just go back with instructions for the district court to enter a written judgment that is in compliance with the oral pronouncement of sentence. I would point out that the government
Again, that's not what, in Rogers, the court sent it back and just said, you got to start again on sentencing. You may choose to now sentence to those things you wrote down in the judgment, or you may choose not to. We won't guess which way you're going to try to rectify this inconsistency. You just need to sentence again.
And I don't disagree with you on that, Judge Harris, to be clear. But getting back to your question, Judge Diaz, so we do think that the court doesn't have the authority to enter a written judgment that's in conflict with the oral pronouncement of sentence. We think that falls outside the scope of the appellate waiver. But I also...
But you didn't raise the argument about the court not having judicial authority on this, delegating to the probation officer until after. You didn't raise it in your opening brief. So why didn't you waive it?
So that's absolutely true, Judge Thacker. And I think under, perhaps if the government was asserting that I had waived the argument, that it probably would be waived. However, I will point out that in page 14 of the government's brief, the government has chosen to treat the response to the motion to dismiss as incorporated into the brief and actually urges this court to reach the issue. The government states that, if you're remanding, that the United States respectfully requests that this court decide another issue raised by Singletary in his supplemental brief. So I think we're
So if we did reach the issue about the, delegating judicial authority, what about our precedent in U.S. versus Miller, where we've held that courts may use non-judicial officers, such as probation officers, to support judicial functions as long as a judicial officer exercises ultimate responsibility?
Absolutely, Your Honor. And this is the problem here, is that the condition as written doesn't make clear that it is merely giving the probation officer ministerial authority. And in fact, it's not clear from the condition that Mr. Singletary has the ability to incur new credit charges or open a new line of credit. It seems to keep that whole decision-making authority to the probation officer. And I would point out that the language of 5D1.3D2 makes this clear. The problem, the government is seeking to defend the condition, pointing to the language of 5D1.3D2, but actually when you look at that language, that shows you how you could craft this condition without having an impermissible delegation of authority. Because when you read the entire condition as stated, it says, if an installment schedule of payments of restitution or a fine is imposed, a condition prohibiting the defendant from incurring new credit charges or opening additional lines of credit without approval of the probation officer, unless the defendant is in compliance with the payment schedule. That makes it clear that the defendant, in fact, can do these things, but if there's an installment schedule and if he gets behind on his payments, at that point, it makes it clear, puts the defendant on notice, hey, you're going to have to start going to your probation officer to get approval of these things. And so instead of just, the problem with this condition is that it's sort of chopped off the beginning and chopped off the end. And so it makes it unclear as to whether Mr. Singletary has this restriction, or it just gives the probation officer the authority. And so I think that is the problem here, is that it sort of chopped off that beginning and chopped off the end. It makes it unclear. I would also point out that really there doesn't seem to be any need on the record in this case to impose this condition at all. And I didn't sort of draw this out in the briefing, so I'd like to point it out. You know, the only restitution that was ordered in this case was the $985 that Mr. Singletary stole from the Old Time Barbecue, but that amount was seized by the police immediately after he was arrested. And at sentencing and through the plea agreement, that amount was forfeited. And so at the sentencing, defense counsel asked the district court to permit that amount forfeited to pay for the restitution, and the district court permitted that. So the restitution has been completely satisfied in this case. So I would also just point out, I think on remand, the district court may very well reconsider this decision, or actually it never decided to impose these conditions, we think, but I think on remand, I think it's likely that the court wouldn't impose these conditions because they seem to be in conflict with 5D 1.3D2.
Ms. Leiston, getting back to the issue of waiver, what do you think is the government's responsibility when the defendant files an Anders brief in a case where there's an appeal of appellate rights in the file, a waiver of appellate rights, sorry?
Your Honor, in all of my other Anders cases, I have to say that the usual procedure by the government is that they typically file a motion to dismiss. It's a very boilerplate motion to dismiss, and I typically file a very boilerplate response. It may not be the rule that the government is required to immediately move to dismiss, but I think it would make it a lot easier on the Office of Staff Counsel if the government would timely assert what is basically an affirmative defense to the appeal. Because, yes, Your Honor.
Can I ask why you think it's not the rule that the government should immediately move to dismiss? The rule is under 27F that a motion to dismiss based on a jurisdictional ground should be filed within the time allowed for the filing of a response brief. So,
Your Honor, I admit that I was not aware of that rule. So if that is the rule, then I would urge this court to apply it here, because I don't think the government has timely asserted its motion to dismiss.
and I just have one follow-up. So, and this goes back to Judge Diaz's question, because I am trying to figure out how this is supposed to work. So if the government files a motion to dismiss, but then after our excellent court staff does an Anders review, if additional issues are identified, is the government going to have to file another motion to dismiss to explain why those issues also are within the scope of the appeal waiver? Might it not make sense to allow the government to just do one?
So if this court, and Your Honor, I know my time has expired, if I may just answer your question.
Absolutely.
If this court, once there's an Anders brief and the government files a motion to dismiss, I believe that this court conducts an Anders review with an eye towards that appellate waiver, and specifically looks for issues that would fall outside of the appeal waiver. So I presume that if this court ordered supplemental briefing on a potentially meritorious issue, it would be an issue that would necessarily it would be an issue that this court would necessarily think might fall outside of the appeal waiver. And so at that point, it would issue a supplemental briefing order, and the government could explain in the supplemental briefing why it felt that this issue did indeed fall within the appellate waiver. I don't think a second motion to dismiss would be necessary.
All right, thank you, Ms. Leiston.
Thank you, Your Honors.
Mr. Bragdon, it appears your video is now working, so whenever you're ready, go ahead.
Thank you, Your Honor, and may it please the court, my name is David Bragdon, and I represent the United States. I wanted to start by making an apology for two errors in our brief that were pointed out by defense counsel. One is that I think we mentioned in the brief that defendant had agreed as part of the plea agreement to conditions of supervised release, and that, as they pointed out, was untrue. And the other thing I wanted to point out is when we cited the 11th Circuit Nash case with respect to the delegation of authority issue, we made an overstatement by saying that it was exactly the same condition, and it's not. I do believe it's analogous, but we can discuss that in a minute when we get to those issues. I wanted to start by addressing the the Anders issue and whether or not we waived by not making a motion to dismiss. And I think the most important point for that is that it was not actually timely for us to make a motion to dismiss with the defendant's opening brief, because they didn't raise an issue that a motion to dismiss would have applied to. The only issue they raised was an ACC issue. And this court has held, I think I've got the site, it's United States versus Cornett, 932 F3D 204. In that case, the court has held that an appellate waiver doesn't limit a defendant's ability to raise an argument that he's not an armed career offender. And so we could not have, a motion to dismiss would not have applied to that issue. And so what we did, and our practice in that regard, and if it's wrong, we can certainly change it, but our practice is where there's an issue raised that's covered by the motion that will be covered by our appellate waiver, we file a motion to dismiss. If there's an issue raised that is not covered by the appellate waiver, we write a letter and attempt to preserve our ability to make a motion to dismiss later. And as soon as this court brought up an issue that was covered by the motion to dismiss, at that point, we did, that would have been covered by the appellate waiver, we did raise it. So I think the appellate waiver is an issue here. And
sorry. So I understand your argument makes a lot of sense, and I understand it. And I understand why it would take care of any waiver issue. Like it would be hard to say that you waived the right to rely on the appellate waiver, given the letter and the sequence of events. But how do we mesh this with our new Rule 27F, with with our new rule on timeliness, which is that the motion to dismiss has to be filed within the time allowed for the filing of the response brief? Can you just walk me through that? You would read that so that it means that, I don't want to put words in your mouth. So how is it timely under 27F?
So, Your Honor, I had not looked closely at that rule, to be candid, but what I would recommend to the court is that they would say, if an issue is raised in an Anders brief or otherwise, then we need to file a motion to dismiss at a timely point there. If an issue is raised for the first time later, that would have been covered by a motion to dismiss and supplemental briefing, I think we still can raise it at that point, because we did not have an opportunity to raise it earlier as to that issue. I think otherwise it would put us in the position of filing a motion to dismiss with almost no substance in every case, just thinking, well, maybe there could be supplemental briefing that would require a motion to dismiss. And I think that's probably not the best use of the court's resources. So that's my answer.
Well, the problem though is that it's also not the best use of the court's resources to have a issue identified by the court as having some merit, require briefing by the appellant, and then have the government come back and say, oops, never mind, we're going to rely on the appellate waiver at that point.
Well, I think that's why we thought that mentioning the appellate waiver in the Anders letter was a middle ground, because in that, I mean, we have mentioned, that the government's reserving its right to raise appellate waiver, and so we flagged that issue for the court. And again, if that's not the way the court wants to do it, we will certainly change that. But that's my position today. Yes.
Sorry, and just so I'm clear, you only do this in cases where the Anders brief only raises issues that are outside the scope of the appeal waiver?
I'm not.
Because the letter doesn't say that. Okay, sorry, go ahead.
I'm new to our appellate division. That is my understanding of our office's practice. And I'm not going to say that we're perfect and always doing it, but my general understanding is that we would have filed a motion to dismiss had there been an issue raised that was covered by the motion to dismiss.
Okay.
Um, so let me move to, I do agree with the question or point raised by Judge Diaz earlier. We would make a distinction between the delegation of authority issue and the Rogers issue when it comes to the appellate waiver. And so I'd like to hit the Rogers issue first. I think the question here is, there are a very narrow set of exceptions that this court has recognized when it will find a way out of an appellate waiver. And yes, Your Honor.
Counsel, but that's exceptions we have found that will allow a defendant to challenge his sentence, even though he waived challenges to his sentence. We have never considered a case where a defendant comes in and says, I'm not challenging my sentence. I'm fine with my sentence. I would like you to take out that extraneous language from my judgment because it might confuse someone into thinking I had been sentenced to those conditions as well. And the only case I could find that considered something like this was in the Seventh Circuit, where they said, that's not covered by your appeal waiver. You're not challenging your sentence.
And maybe I misfocused my researching efforts in that regard, Your Honor. I think that is an interesting point, but what I had understood to be the appellant's argument in this case was, and I think in their motion to dismiss on page 6 of their of their response to the motion to dismiss, what they say is that this is a violation of a clearly established constitutional or statutory rule. And when I look at that, I think that for it to be clearly established, it must have been in existence at the time the court considered it. And Rogers had not been in place when the district court sentenced it. Rogers came up with a new rule for these scenarios, one that was not being followed by courts previously. And as further evidence that that this was not a well-known or clearly established rule, the appellant filed an Anders brief, so they did not flag it or see it. And when the court initially ordered briefing on it, it ordered briefing not on the pronouncement issue, not on what we now see as the Rogers issue. It ordered briefing on the failure to explain issue. And so I think that this is a new case. It's a new approach, and I think under that new approach, it's not clearly established to come under an exception. And so,
but how could the plea waiver be knowing, be a knowing waiver? Because how could the defendant have contemplated that the district court would haul off and add conditions after the sentencing was over?
Well, I would say that this was something that was first of all, let me take two steps back. First of all, appellate waivers are meant to cover things that defendants do not anticipate. In the Archie case cited by defense counsel, it talks about the fact that changes in law and other things like that are covered under appellate waivers. The second thing I will say is that this practice, has been identified as wrong, but I don't think it was unusual. I don't think it was an unusual situation for a court to fail to pronounce. And I did find a couple of cases, in particular, I think United States versus Norris, 457 F Appendix 333. It's a 2011 case. And that's a case where there was an appellate waiver, there was an Anders brief, and there was a failure to pronounce any of the conditions by the district court. I went back and looked at the sentencing transcript. And so those things happened, and they were accepted up until Rogers created this new rule. And so I'll answer additional questions about that issue, but I do want to take a minute and turn to the improper delegation if there's not additional questions on that issue. So I wanted to look at improper delegation, and I wanted to start by looking at some of the other delegations that were given in this case that aren't even challenged by the defendant. So it delegates to the probation officer to decide whether or not the defendant works. So it orders the defendant to work, but it allows the probation office to make an exception. And they can make an exception as to whether or not he even looks for work. That's the third condition of supervised release in the standard conditions. They delegate to the probation officer to make exceptions as to whether or not he stays in the district. That's the seventh condition. So they say you need to stay in the district, but you can get exceptions from your probation officer. They delegate whether or not he interacts with people engaged in criminal activity. So they say don't interact with people engaged in criminal activity unless the probation officer makes an exception. And so that's another area of delegation. They delegate to the probation officer who he notifies about the risks he poses. And they even give the probation officer the approval of where he lives. And so there's a lot of authority that's routinely applied in these cases. And there's no, those issues aren't even questioned here. The second point I'll raise is a practical one, and that is this condition of supervised release would not work effectively without delegation to the probation officer. It requires the defendant to get approval for each charge he makes, each line of credit he opens. And if he had to do that with the court, each time he makes a charge, each time he opened a new line of credit, there would be a major delay in every financial action the defendant took. And this is exactly the sort of condition that probation officers need to be able to manage on a day-to-day basis, knowing everything they know about the defendant, know how to handle that. It's exactly the sort of thing that requires delegation, requires an on-the-scene officer. I did want to raise the point raised by the defendant where they talk about the difference between this condition and the one in the sentencing guidelines. And the sentencing guideline, this condition has been around for 25 years. To my knowledge, it has never been struck down by a court or found improper. And what I would say is it's the same delegation. It's the exact same delegation. It's just different circumstances as to when it's delegated. And so in the sentencing guidelines, they delegated in one specific set of facts. Here, the court delegated it as to all circumstances, but the same amount of delegation of approving each account and approving each credit charge is done in both. When you look at the only circuit that has addressed a similar condition is the 11th Circuit in the Nash case. And when the condition there was the defendant shall secure approval from the probation officer before opening any checking, credit, or debit account. So here it's lines of credit and charges. There it was approval to open a credit, debit, or checking account. And the court said that we're going to distinguish between delegation of a ministerial act and delegation of imposing the sentence itself. And when they looked at it, they said the imposition of the sentence is the decision that the defendant needs to be supervised on this issue. The court wants the defendant to get permission before he does, before he opens any new account. That's what the court's decided. Which accounts he opens is a ministerial act, and that's an appropriate act for delegation. And I think that fits with the overall framework. The other line of cases that I would point the court to, and we did not cite this in our brief, but there's a line of cases that deal with the probation officer's decision about that deals with the issue.
Mr. Bragdon,
of
before you go on to those next cases, back to Nash. So
Yes.
in your view, the fact that the probation officer ultimately has the authority to withhold approval of any line of credit or checking account, you don't think that equates to the probation officer having the authority to decide the nature and extent of the defendant's punishment and therefore is an improper delegation?
That's correct, Your Honor. And actually, there is this case is not in our brief, but I'd point the court to the unpublished case of United States versus Cook. It's 637 F Appendix at 744. And in that case, the condition forbade the defendant from using his computer to access the internet, even at work, without approval of the probation officer. And so it was very similar, different kind of issue, but very similar in how it was framed. Don't use your computer without approval of the probation officer. Don't use the internet without approval of the probation officer. And the court found that what that condition did is it essentially prohibited a set of conduct, but gave the probation office discretion to make exceptions to it. And the court found that that was not an improper delegation. And there's a Fifth Circuit case that addresses a similar condition to that, the internet issue, and reaches the same conclusion. And that's United States versus Halverson, 897 F 3rd 645. And I think that, again, we have to look at, could the court have said, okay, come back to me, come back to the judge. Every time you want to use the internet, you have to come back to court. That's not workable. And so the court said, well, can we delegate that permission? That we want there to be permission, we want there to be approval, but we're going to delegate that to the probation officer. And I think the fact that that defendants are allowed to go back and request changes to their supervised release under Rule 32.1, or bring these things back to the attention of the court, does provide some limits. But I think it's a reasonable amount of discretion. And in United States versus
Counsel, sorry,
Yes,
it's
Your
Judge Harris. So I'm hearing what you're saying, and I do I understand what you're talking about in terms of sort of the functionality of this system. But I suppose another way of looking at it might be that the way it's set up now almost makes it too easy for courts to just impose like a whole raft of conditions without thinking about them very carefully, let the probation officer figure it out. And this case does give me some concern about that, because it is hard for me to see why this credit card charge condition was imposed on this guy. I mean, under the guidelines, that's for people who have installment plans for their restitution or their fines, and they've fallen out of compliance with the plan. That's when the Sentencing Commission thinks that's appropriate. So I have some concern here that, had the defendant actually been sentenced to this condition, it would have been without a lot of thought. And it would have been made easier by the fact that, and I really don't mean to, no disrespect to the judges, and I know how busy they are and how hard these jobs are, but it's almost, I could imagine a circumstance under which you're like, oh, we'll just leave that to the probation officer. But that's not who's supposed to be sentencing people.
Well, Your Honor, I think that is actually a really good point. And I think one of the reasons why this case is not, maybe not the best case to consider this issue, is the fact that the court did not explain this condition. And as counsel
also didn't actually sentence the defendant to this condition, but let's assume for a minute he had been conditioned, he had been sentenced to it, it would have been without explanation, right?
Right. And so this court has a line of cases to deal with exactly the issue that you mentioned, so that the court does explain it, so the court does make sure that that it's imposed, that it's specific to the case, and so on. And so I think that line of cases deals with the concern you're raising. Now, here we believe that that the appellate waiver that the appellate waiver cuts off the defendant's ability to raise the explanation issue. But I think in general, the requirement for a court to explain and the line of cases requiring the courts to explain supervised release is relatively new. I think courts are still getting used to that line of cases, and the explanations will probably be better if we look at this in another year or two from now. But I would say that a court needs the flexibility to give the probation officer the ability to manage day-to-day things that a court can't take into account. And I think knowing the defendant's financial situation, looking at, is this charge okay? Is this charge not okay? Those sorts of things are exactly the things we would want someone on the ground to take a look at. Do we want the court to explain why it's necessary? Of course we do. Do I wish the court had done this here? I absolutely do. But I don't think that makes the whole condition an unlawful delegation of authority, is what I would say. And I did, I'm actually, I tried to keep track of my time, but am I out of time?
You're over time, Mr. Bragdon. So if you want to make a concluding statement, go ahead. But
well, I would just thank you for your time, and I would ask the court to affirm.
all right, thank you. Ms. Lyston, you've got some time for rebuttal. Go ahead.
Your Honor, just a few brief points. I would, going back to the government's discussion of when it files a motion to dismiss and when it doesn't, and the fact that the Andrews brief didn't bring up certain issues, I would just point out that, you know, the whole reason for filing an Andrews brief is to put the court on notice, is to ask the court to conduct its own review, because goodness knows, you know, attorneys, we miss things all the time. And so when you file an Andrews brief, you are asking the court to look at the entire record, see if there's anything in here that I missed, which I definitely did. And so I think it would behoove the government to go ahead, if it intends to assert this affirmative defense of waiver, it needs to go ahead and let the court know that. I think that would definitely be the better rule, and I'm sure the Office of Staff Counsel would really appreciate that, as I said. So in terms of the delegation, Your Honors, I think, again, the problem with this particular one, as it's currently worded, is that it just gives the probation officer all authority over a very, and imposes very significant restrictions on the defendant's financial liberty. And it gives the probation officer the ultimate authority to decide if the guy is ever going to get to, tank up, his at the gas station and use his credit card to tank up or anything. So we do think that is improper. And the problem here is that it didn't track the language of 5D1.3D2, that it doesn't make that clear that should really only apply if he falls out of compliance. And we certainly don't want to put the district court in the position of micromanaging every financial transaction for the defendant. But it does need to be clear under what conditions the defendant can do these things. Your Honors, unless you have any other further questions, I really don't believe I have anything else to say. We would ask that this court vacate the judgment and remand it for resentencing on the conditions.
Ms. Lyston, as you were talking, it reminded me of a point that when I was thinking about this case, and you suggested that the government should, in every case, file a motion to dismiss. I have recalled cases where the government has not filed a brief. The court found an issue worthy of discussion and briefing, and then the government elected not to stand on the waiver and proceed to the merits of those arguments. So it's a double-edged sword, I guess, because if they file a motion to dismiss in every case, that's going to signal to the court that we don't need to require briefing, and it might actually inure to the detriment of certain clients in some cases.
It absolutely can, Your Honor. I don't deny that if the government had initially moved to dismiss this case, and Office of Staff Counsel had only reviewed for issues that fell outside the appellate waiver, it's possible that the court, might have missed this, and we wouldn't have this great discussion that we're having today.
Well, we wouldn't have missed it. We would have said it's covered by the waiver and we're not going to pursue it, right? So, okay, well, thank you very much. Mr. Bragdon, Ms. Lyson, the case has been ably argued. We appreciate the arguments presented here today. As you both know, we would typically come down and greet you personally. We can't do that this morning, obviously, but I want to thank you nonetheless and greet you virtually, and hope that you will stay well and stay safe. Thank you very much for your arguments. The court will take a recess, and judges, let's take a break before we conference, and we'll come back in about 5 minutes. Will that work? 10?
Mm-hmm. Great, thank you.
Great.
Thank
So I have the clerk adjourn court. Sonia Dow.
Thank you.
Madam Clerk, are you there?